Hello everyone, welcome back to my YouTube channel Legal World. Myself Dr. Seema Goyal. As in the series of Banking Law and Negotiable Instrument Act, I have discussed many important questions relating to the banking law. Today in this video, I am going to discuss one more important question relating to the banking law that has been asked for many times in the previous year question papers. My question is, define the term customer and also explain the relationship between customer and the banker in detail. This is my question. If we talk about the meaning of the customer, a customer is a person who is accomplished to frequent a certain place of business. So a person who regularly or repeatedly makes purchase of or has the business dealing with the tradesman or the business, he is known as customer. According to Professor Hart, a customer is one who has an account with a banker or for whom a banker habitually undertakes to act as such. In determining whether a person is a customer or not, neither the number of transactions nor the period during which business has been conducted between the parties is material. Relationship between the customer and the banker flows from the services rendered to its customers. Hence, a person can be said to be a customer if the following conditions are satisfied. First condition is duration of the dealing is not essential. Even a single transaction with the banker constitutes a customer. As in the case of Central Bank of India versus Gopinathan Nair and others, it was held by the Honorable Court that as soon as a banker accepts money from any person on the footing that he will hand over his check up to the amount standing to his credit, the person becomes his customer. And money can be accepted even by the checks also. So the relationship between the banker and the customer starts as soon as the first check is paid in and accepted for the collection, and not merely it is paid. According to Lord Davey, a customer is a person who has some sort of account with the banker. Second condition for the person becoming a customer, that is frequency of transaction. Although the frequency of the transaction is not essential to called as a customer of the banker. Third condition is nature of dealing. A banker should have dealing with the bank in the nature of regular banking business. So the person should have certain type of account with the bank. Either it may be a deposit account, it may be a current account. If a person having dealing with the bank only in respect of utility services such as safe custody locker, then he can't be called as a customer. This utility services provided by the customer does not constitute a customer of that person. Constitute a customer. And the next condition is by legal entity he may be a customer. Customer may be an individual, a firm or a company or a government department or a society. This means a legal entity, whether it may be a corporation or it may be a natural person, may be a customer. Next condition is introduction essential. The banker must take due care to satisfy himself about the good faith as well as respectability of the new customers. It is essential for the purpose of protection of the bank. So these are the certain conditions which are essential to become a customer. Please, relationship between the banker and the customer. If we talk about the relationship between the banker and the customer, banker and the customer relationship flows from the services rendered by the bank to its customers. So the relationship between them is basically contractual in nature. And such a relationship between the banker and the customer may be regulated by, number one, the general provisions of the law of the contract or by the rules of agency and the banker practice. So the relationship between the banker and the customer may be of the following types. First relationship, that is the debtor and the creditor relationship. The relationship between the banker and the customer is that of debtor and the creditor. But who is what? That depends on the status of the customer's account. In case account is showing credit balance, the banker will be a debtor and the customer will be the creditor. While in case of debit balance or overdraft, the banker will be a creditor while the customer will be a debtor. This means relationship between the banker and the customer, who is the debtor and who is the creditor, depends upon the state of the customer's account. When a customer deposits money with the bank by opening the bank account. It amounts the lending money to the banker. In that case, the banker becomes the borrower and the customer becomes the lender. As such, relationship between them is that of debtor as well as the creditor. The bank may make use of such money as it is at the disposal of the bank, and the bank undertakes to repay the amount on demand. So the bank is a debtor of his customer and bound to discharge his indebtedness by the honoring his customer's check. However, when the demand is made, the bank can pay the amount deposited by the customer in any of the kind, whether it may be in the form of notes, coins, or subject to certain type of conditions also. First condition is demand for payment. Means a bank is not ordinary debtor. As a bank is not under obligation to refund the customer's deposit unless the demand for repayment is made by the customer. Second one is proper time and place for the demand is also essential. Also, the obligation to repay the fund deposited is limited by the bank when it is made at the proper time and place. This means that is limited to the branch of the bank where the account is opened. So the customer can issue the check only on the branch bank of the bank where a customer has a account. Also, the demand for payment must be made during the working hours of the bank. Third is proper manner of the demand is also essential. So it is also essential that the demand for repayment should be made in the proper manner in accordance with the law. Demand should be made by filing the prescribed pro forma, presenting it at proper branch of the bank. So the demand should not be made verbally or through the telephonic message. So the demand can be made either by draft, either by check, etc. And no time bar. This means the deposit with the bank don't become the time bar but on the expiry of the specific period. So this was all about the relationship between the debtor and creditor as well as debtor relationship. And the second type of relationship between the banker and the customer, that is of trustee and the beneficiary relationship. Banker also assumes the position of the trustee when it accepts the security or the valuables from the customer for the safe custody. Banker also acts as a trustee in respect of the checks and bills of deposits by the customer for the collection till they are collected. And the banker also acts as a beneficiary as it acts for the benefit of the customer also. So we can say that the relationship between the banker and the customer is that of trustee as well as the beneficiary also. And the third type of relationship between the banker and the customer, that is of principal as well as agent relationship. A banker also acts as an agency. Banker also acts as an agent of the customer and performs a number of agency functions for his customer also. He collects checks on the behalf of the customer and also makes the payments of the various dues of his customer, such as insurance premium, etc. And this type of relationship also makes the relationship between the banker and the customer as that of principal and agent relationship. And the next type of relationship between the banker and the customer, that is a bailier and bailee relationship. Bank also acts as a bailee as it keeps the valuable articles, ornaments, title deeds, etc. of the customers. And the bank acts as a custodian of these things. And the bank is under implied obligation to return these articles that has been kept safely. So the bank is a bailee and the customer is the bailier. And the bank keeps one key of the customer's locker with it and the another key is kept with the customer. But the locker can't be opened without using both the keys. And the customer pays rent for the locker also. And the next type of relationship between the banker and the customer, that is of leisure and leisure relationship. When a bank provides locker facility to the customer, then there is a leisure and leisure relationship between the banker and the customer. As the bank provides its immovable property in the forms of locker to the customer, the banker is called leisure and the customer is called leisure. As he enjoys the property of the bank, here the provisions of the Transfer of Property Act 1882 will apply. It's all about the relationship between the banker and the customer. And the next one is termination of the relationship between the banker and the customer. If you talk about the relationship between the banker and the customer, that may be terminated in the certain ways. It may be terminated by the mutual agreement, or by the notice of the termination, or by the law also. If we talk about the relationship between the banker and the customer, that may be terminated by the mutual agreement. The relationship between the banker and the customer may be terminated by the mutual agreement. Second one is termination of the relationship by the notice of the termination. The customer has the right to close the current account on the draft notice of the termination. This means customer has right to close a current account on demand, and the no notice by the customer to a banker appears necessary. However, the banker can't close the account of the customer without giving the proper notice. Or it may be terminated by the process of law also. The relationship between the banker and the customer may be terminated by the process of law. That may be by the death of the party, by the insanity of the party, by insolvency of the party. If we talk about the death of the customer, the notice of the death of the customer, the banker stops the payment of the customer, and also the banker's authority to pay the checks is also invoked, is also revoked. Second one is insanity of the customer. The lunacy or the insanity of the customer may also terminate the relationship between them. And the banker's authority to pay the checks is revoked by the notice of the insanity. Third one is by bankruptcy. The bankruptcy or the winding up of the bank, that is insufficient ground for terminating the relationship between the banker and the customer. Similarly, if the customer is a firm, when there is dissolution of the firm or winding up of the firm, then also the relationship between the banker and the customer also comes to an end. And the last one is transfer of the balance account. If the customer transfers the whole amount of the bank to the another bank account, then also the account may be closed by the banker. In this way, the relationship between the banker and the customer may be ended. This was all about the relationship between the banker and the customer. And if you have any doubt, you must put down in the comment section. And don't forget to like, share and subscribe this channel for the further update. Thank you.